In the previous panels, we noted the severity of causing one to violate a Torah law. The argument was that if one is held accountable for giving one advice that results in physical or financial damage, this falls under the category of the case law of one who creates a bar birshut harabim, then certainly one should be held accountable if the outcome of one's advice or actions involves the violation of Torah law. A reference to the severity is noted by the Rebbe in the SICHAH text, drawn from the narrative recorded in Sefer Bereshit regarding the violation of the very first commandment given to Adam and Chava, namely not to consume the fruit of the Eitz Hadar. The Rebbe in the SICHAH points us to a commentary of Rashi drawn from Masechet Sanhedrin, She'ein Mahabchin B'Zchuto Shel Meisit. The statement quoted by Rashi relates to the punishment meted out to the Nachash for its involvement in causing Adam and Chava to violate that first commandment. We noted in the previous panel that when one compared each of the three punishments that meted out to Adam Harish, to Chava, and to the Nachash, the most severe was that given to the Nachash. And in connection to that punishment, Rashi draws the halachic conclusion that in situations involving a mesit, one who facilitates another, causing him or her to violate Torah law, when brought before a Beit Din or a Sanhedrin, the court does not advance a claim on behalf of the accused. As noted, the source for Rashi's commentary comes from Masechet Sanhedrin. We shall first look at the concept of ve'ein to'anin l'meisit, teasing out the legal situations of this concept, and then in the following panel taking a closer look at the link to the narrative involving the Chet Eitz Hadar to this halachic concept. In all legal systems throughout the world, there's a certain degree of commonality in terms of basic principles. In most Western countries, we are fortunate to have a well-developed legal system. When one studies Masechet Sanhedrin, one cannot be but impressed that the legal system that underpinned Jewish life was equally sophisticated as of close to 2,000 years ago. In secular law, we have a division between criminal law and civil law. The rules and regulations for each differ in their respective applications. A similar distinction is made in the Beit Din Sanhedrin system between Dini Mamonot and Dini Nefashot. Civil law, Dini Mamonot, generally deals with relationships between individuals, property, contracts, divorces, negligence, whereas criminal law involves the regulation and the enforcement of rights and how society deals with the violation of those rights in the form of murder, rape, armed robbery, assault, etc. In Torah law, there is a third category, and that is the category of the mesit. And while the topic of the mesit, as discussed in Masechet Sanhedrin, is primarily focused upon one who facilitate another Jew to violate the second of the Aseret HaDibrot, that of Avodah Zarah, Rashi, from the standpoint of the Pshuta Shel Mikra, broadens the scope of the mesit to include one who facilitates a violation of any Torah law. Both the Gemara and Rashi look to the narrative involving the Chet Eitz Hadar as their textual basis. As with all matters legal, there is a great degree of complexity to one who is not attuned to the nuances of the legal system. The following is no exception. The case discussed in the Gemara involves a situation where person A loans money to person B. At the conclusion of the agreed upon time period, A makes a demand of B that the money be repaid. B rejects A's claim, either on the basis that the money had been repaid or that from the very outset he never received money from A as a loan. At that point in time, A has no other option but to leave it in the hands of the court system to decide either in the favor of A, the plaintiff, or B, the defendant. Burden of proof rests with A to demonstrate that he is owed money by B, which generally takes the form of either a contract or, in the absence of a contract, via the testimony of witnesses. Obviously, in the absence of evidence, the judges must rule in the favor of the defendant. The case under discussion in Masechet Sanhedrin involves a situation where there were witnesses testifying to the fact that B owes money to A. The Gemara will look at three situations. In situation number one, the witnesses testify to the fact that B communicated to A in the presence of the witnesses that he owed him or her the money. In that situation, the judges will accept the evidence and rule in the favor of the plaintiff A. If, however, the statement was not made from B to A, but rather the statement was made either to a third party or to the witnesses directly that B owed the plaintiff A money, then that evidence must be rejected by the judges on the basis that it falls into the category of hearsay. The Gemara then introduces a third scenario where A, realizing that B will not voluntarily admit to owing money in the presence of witnesses, arranges to have two witnesses concealed behind a curtain in a different room, whereby he confronts B regarding the repayment of the loan. B, assuming that there are no witnesses, admits to A that money is owed. When the matter comes to court, A produces the witnesses. B's response is that the admission was made in jest, such as, for example, A was constantly harassing him for payment, and to get him off his back, he said yes, he owes him money. In that situation, the judges rule in favor of B, the defendant. The fact that the acknowledgement was made in the presence of witnesses could not be entered as evidence, as B at the time was not aware of their presence, which is something along the line of the now well-established Miranda warning handed down by the Supreme Court of the United States in 1966, in which law officers interrogating a suspect must warn the suspect that they have the right to remain silent and that anything that they say can and will be used against them in a court of law, along with other rights afforded the suspect. Otherwise, whatever admissions they would make to the law officers would and could not be admissible in a court of law. Returning now to the situation where B admits that he owes money to A in the presence of witnesses who had been secreted away, and hence B was unaware of their presence, the Gemara goes on to place some limitations and qualifications. One is that the response of the defendant B, that the confession was not to be treated seriously, it was said in jest, come from the defendant, him or herself. It cannot be introduced by others involved in the case. However, in a dinei nefashot that could lead to incarceration, and in the early days of the Sanhedrin, even death, the rules are somewhat different, and even if the defendant does not raise the issue that the confession was not real, the judges themselves are required to offer the defendant the possibility that could nullify the evidence of the witnesses. This distinction between dini mamonot and dini nefashot is also reflected in the differences between civil law and criminal law. The standard of evidence in civil law is the preponderance of evidence, which means the judge or the jury will weigh up both sides of the argument and rule in favor of the side that has presented evidence that has a greater likelihood of reflecting the truth. In criminal law, we have the famous expression of beyond a reasonable doubt. It is the responsibility of the prosecution to present proof that a reasonable human being could accept. On account of the higher level of evidence required in din nefashot, not just the accused, but also any third party, including the judges, may introduce the possibility that a confession was made in error or in jest, which brings us to situation number 4, referred to in Masechet Sanhedrin, that in a mesit situation, third parties are not to look for reasons that might undermine the case against the accused. In the next panel, we will take a closer look at the text of the Gemara and the link between the mesit and the punishment meted out to the Nachash.